Okay, I think we can get started. You good, Jesse?
I think we're ready.
All righty. Hi, everyone. Thank you for joining us. We are very excited to welcome you to Air Quality Law 101. As you can see on the screen, this is the first installment of a new webinar series that we are launching. This is co-sponsored by the Environmental Law section of the California Lawyers Association, as well as the California Young Lawyers Association, CYLA. And we're starting off with air quality. In a couple of weeks, we'll have one on water law and another one on CEQA. And the idea is that these are very accessible, kind of entry-level nuts and bolts introductions to different topics in environmental law. In future years, we're hoping to cover additional topics. And we're going to wrap up with an orientation to our 30th annual Environmental Law Conference. This is traditionally held at Yosemite. Unfortunately, this year, because of COVID, it's virtual, but we encourage you all to check it out once the registration goes live. And I'll mention that generally for law students, young lawyers, and public interest, it's either free or reduced rate. So it's a pretty good deal. Couple housekeeping measures. This is being recorded, so it will be available for viewing later. Our idea is that these will be kind of educational, informative resources that we'll make available for free, and people can look at them later if they're interested in certain topics. And then you'll notice in the very bottom of your Zoom screen, there's a little comment bubble that says Q&A. That's how we'll be taking questions. So feel free to type in your questions as we go along. Next slide.
There we go.
Great. So just a couple of introductions. The California Lawyers Association is the primary bar association in California, and they're our umbrella parent org. It's all volunteer, and within the California Lawyers Association, there's the Young Lawyers Association, CYLA, that represents everyone in their first 8 years of practice. And there are 17 practice area sections, one of which is the environmental law section. And each of these sections puts on a bunch of programming throughout the year, have a lot of resources and services for lawyers who practice in that area. There's business law, tax law, international law, real property law, everything you can think of. Next slide.
There we go.
Yeah, so delighted to introduce our speakers. My name is Marissa. I am an environmental attorney at Greenberg Glusker in Los Angeles, and I serve as the liaison to the environmental law section from the California Young Lawyers Association. You'll mostly be hearing from Jesse Fierro, who is assistant counsel at the San Joaquin Valley Air Pollution Control District. And her work primarily consists of civil enforcement of regional environmental regulations within the 8-county San Joaquin Valley. She also does federal appellate work related to Clean Air Act implementation in the 9th Circuit and DC Circuit. And she also advises on employment and public agency issues. We're also really thrilled to have Byron Chan, who is a senior associate attorney at Earth Justice. He works with the Community Partnerships Program in the Los Angeles office. And prior to joining Earth Justice, he was in private practice at Milbank. So you'll hear from both of them. And Jesse, I'll mention, is our incoming chair of the environmental law section, so very much involved. She also runs our book club. And Byron works with another one of our executive committee members. So thank you for joining us. Next. So a quick overview. Jesse is going to give a crash course, a speed run through Air Quality Law 101. And then we will talk about some work examples and projects that people have been involved with, just to give you a sense of, what does it mean to be an environmental lawyer? What kinds of things would you do if you're interested in air quality issues? And then I'll just give a quick overview of some opportunities and resources and ways to get involved with the organizations, and then we'll open it up to Q&A. Jesse, feel free to take it away.
All right. Thank you so much, Marissa. And thank you all of you for being here today. We really appreciate your interest in this series, and we're very excited to present it. As Marissa said, this is meant to be a crash course. And so there's a lot I could tell you. I'm going to try to keep my portion to about 20 minutes or so, just to give you a lay of the land. And so there might be times in the slides where I skip over things. You'll have this as a resource and a reference. We can post this later. If you have questions about specific things I either skipped or maybe didn't go into great detail on, we, of course, can cover that during the Q&A. But really what we wanted to do was set the stage so you could see where your future may lie in terms of air quality and where the work opportunities are for addressing this really important issue. So people have been worried about air quality for quite some time, and certainly in the early 1900s, there were some really key moments that rose people's attention and awareness and made people realize we need to start addressing this air quality problem, ever since the Industrial Revolution. And some of the famous examples would include the Great Smog episode of London in 1952, when many people died because of temperature inversions and a lot of pollution in industrial and residential areas. We had the Dust Bowl in the middle of the United States in the early to mid 1900s. We had smog episodes in Los Angeles in the 1940s through 60s, people wearing gas masks in the streets. In New York in the 1966 had issues with its Thanksgiving Day parade because of smog. But it wasn't just these big cities. It wasn't just London and LA and New York. I mean, even Donora, Pennsylvania in 1948 had a significant smog episode where a lot of the population in that region experienced health effects. And so we have this history that prompted Congress and a variety of agencies to start addressing the problem. And as I'm going to show you later, so much progress has been made. We've proven that we can address this problem, we can make things better, but there is still a lot of work to do, particularly in California. There are places in California, like the region I work in, the San Joaquin Valley and LA, and even in the Bay Area and Sacramento, where we consistently find ourselves on those lists you don't want to be on, the lists that have the most challenging air quality situations in the nation. And it can be a little disenchanting sometimes because these lists don't show the progress that has been made. And as everyone's making progress, sometimes those of us who were in last place continue to be in last place. And there's a lot of nuance that can go along to these lists, but these lists show you that California is where it's at when it comes to having opportunities and needs to address air quality in our nation. With Los Angeles, Bakersfield, Visalia, Sacramento, San Diego, as you can see, we're on the list of places that need to keep doing more to improve our air quality. So how do we do that? Well, part of how we do that is through science and technology and just understanding, where does our air pollution come from? What does it really mean? Well, there are many sources of air pollution, and each one has its own challenges technically and socially and from a regulatory standpoint. For example, when most people think of pollution, they might think of factories spewing pollution, and they might think of traffic jams with a lot of cars belching smoke out of their tailpipes. And of course, there's truth to that, but there are smaller sources and sources spread all over the place that make the challenge of tackling air pollution is so multifaceted. But what it means is that we have areas in California, because of the emissions that go into the air, we tend to have high ozone concentrations in the summertime and high particulate matter concentrations in the wintertime. Well, ozone is not emitted directly, but ozone forms in the atmosphere through photochemical reactions from oxides of nitrogen or NOx and volatile organic compounds, sometimes called reactive organic gases or ROG. So you get these materials in the air, and in the presence of heat and sunlight, which California has a lot of, you get high ozone concentrations. In the wintertime, I mentioned particulate matter. There are many things that make particulate matter especially challenging. One is that the size of the particle can have a big influence on how health impacting those particles are. So early in the days of regulating PM particulate matter, we were worried about PM10, which are 10 microns or less in diameter. This picture of a human hair. So like if you can look at your own human hair and imagine that there are, 5 to 7 PM10 particles that would go across your strand of hair. These are teeny tiny little particles. PM2.5 is where most of our regulatory efforts are today. And then, so they're much, much smaller. And they also represent a wider range of chemicals. And so even though we tend to address PM2.5 just in terms of concentration without regard to the chemical composition, the fact of the matter is different chemical compositions of particulate matter are going to have different health impacts. So that just adds to the challenge. So addressing these from a regulatory standpoint, under the Federal Clean Air Act, we've made a lot of progress for ozone and particulate matter. The first version of this act came out in 1955 as the Air Pollution Control Act, and then in 1963 and 1967. These early acts were basically, they were more research oriented, and they didn't put in place very strong regulatory measures to really encourage regions to do something about the pollution in their air. It was really the 1970 Clean Air Act that established better mechanisms for the newly formed EPA to work with states to address air quality. And a lot of good came out of all the environmental regulations that came on the books in the 1970s, but in many cases there was room for improvement. So Congress did amend the Clean Air Act through major revisions in 1977 and 1990. So it's the 1990 Clean Air Act amendments that really govern the regulation of air pollution today. There have not been any major amendments to the Clean Air Act in the past 30 years, but there have been several minor amendments. Little definitions will get added here and there through other acts of Congress. And there's also implementation of the Clean Air Act through EPA regulations. It really is a living statute as EPA adopts new air quality standards, implements those standards, and various states and regions work within the Federal Clean Air Act to meet the provisions contained there. So the crux of the Clean Air Act really comes from the National Ambient Air Quality Standards, or NAAQS, and EPA will establish a NAAQS and then designate regions and states as either attainment or non-attainment, and then assign non-attainment classifications. And with those classifications come certain deadlines and responsibilities so that regions are making appropriate and swift progress to these standards. These NAAQS are to be based on public health studies without regard to the cost of achieving the standards. So health experts will evaluate all the available health information every 5 years or so and make recommendations to EPA, and then EPA will adopt NAAQS for 6 criteria pollutants: ozone, particulate matter, sulfur dioxide, lead, nitrogen dioxide, and carbon monoxide. Now, of course, there are other air pollutants, and there's hazardous air pollutants and all kinds of other things in the Clean Air Act to deal with other kinds of pollution, and that's going to be beyond the scope of my overview today. But I do want to acknowledge that those exist and could be part of your work if you work on air pollution issues in the future. And while I note that there are 6 criteria pollutants, the vast majority of our efforts are focused on ozone and particulate matter, because those are the things that California has many regions that are non-attainment for. So then, once an area is non-attainment, what do you do about it? States develop state implementation plans, which are often called SIPs for short. And in these plans, we document current air quality and emissions, we model future air quality, identify specific regulations and other strategies to meet the attainment deadlines contained in the Act, and satisfy progress milestones and make other demonstrations. So it's very prescriptive. The Clean Air Act of 1990 really set forth the basic requirements, and EPA is constantly interpreting those requirements with respect to the various air quality standards that have been approved since the 1990 Clean Air Act. EPA approval of a SIP makes that plan federally enforceable. The state implements the plan by adopting the regulations of fulfilling other commitments. So far I've focused on telling you what happens in federal law, but I do want to spend some time on what's been going on in parallel in California. California has actually been dealing with air pollution through regulation much earlier than the federal government. The very first air pollution control district was the Los Angeles County Air Pollution Control District, which was formed in 1947. Bay Area APCD was created in 1955, and many other air districts have been created since then. California established the nation's first tailpipe emission standards in 1966. That is very important, and why you might hear about the Clean Air Act waiver measures. Under the Clean Air Act, which was approved in 1970 and then amended in 1990, states are not allowed to regulate tailpipe emissions from motor vehicles unless you're California. If you're California, you're allowed to ask EPA for permission. And part of the reason for that is because California regulated tailpipe emissions first. And plus, we have a greater need than a lot of areas. So a lot of people in the media will talk about California waiver measures and mobile sources. And there's a backstory to that is worth understanding if we're going to talk about those measures. And in 1967, the California Air Resources Board was created. People will refer to this as CARB for California Air Resources Board, or just ARB. We have 35 air districts in California. Some of them are very small, single county areas, and some of them are very big, like my own region, the San Joaquin Valley, which is geographically the largest, but of course, Bay Area and South Coast have more people. And the California air districts worked hand in hand with CARB. People will note that the Clean Air Act is a model of cooperative federalism, where states and the federal government work together to achieve air quality goals. Some researchers have talked about the situation in California as cooperative sub-federalism, recognizing that we have California and then many other agencies that are working with the state and the federal government to achieve better air quality for our regions. So what does CARB and what do CARB and the regional boards do? Well, CARB can regulate on-road mobile sources with an EPA waiver, as I just mentioned, and consumer products. The regional air districts can regulate stationary and mini area sources. We can also get to mobile sources indirectly by looking at how things are being, new warehouses, new subdivisions, and how does that increase traffic and emissions associated with traffic. And you'll see those indirect source review measures at San Joaquin and in South Coast. The California Health and Safety Code establishes local authority for our districts to adopt rules to achieve and maintain both state and federal air quality standards. And so when you're practicing in air pollution, it's important to not only know the federal law, but you also need to pay very close attention to the state laws about air quality contained in the Health and Safety Code. When an agency, a regional air pollution agency, adopts a regulation to reduce pollution, perhaps because we committed to do so in a federal SIP, remember, EPA is not allowed to consider the costs of implementation. They're just considering health. But when a local agency is adopting a regulation, we are required by state law to evaluate things like necessity, clarity, socioeconomic impacts, and more. So on the regional level, it's very important for us to look at all those impacts with an eye toward, of course, achieving the public health standards for our regions, but also acknowledging, as the state directs us to, maybe the socioeconomic costs and whether or not the rules were adopted are necessary for achieving those particular goals. I do want to point out that CARB does in fact establish state ambient air quality standards as well, and designates attainment areas and non-attainment areas. And while many of us look to those state standards and want to achieve them in time, of course, it's the federal standards that really drive a lot of the activities that we are doing. Once an agency adopts a rule, there's still a lot more work to do. An agency will adopt the rule, but then we have to implement it at the local level, and that typically involves permitting and enforcement. So for the permitting process, and why I wanted to tell you all about this is sometimes what I work on and what I see private attorneys working on is helping clients go through the local permitting process. So not only is it enough to know the federal Clean Air Act and the state Health and Safety Code, but when you represent a client that has perhaps a business in a particular region, you need to be very familiar with your local air district and any regulations that they have that might apply to your client. And so if a facility is installing or modifying equipment that may emit air pollution, they need to obtain a permit from the regional permit authority prior to and even installing that equipment. There are exceptions to this. But in general, you get an ATC, an authority to construct, before you install the equipment. And then once you install the equipment and you have it tested and inspected, that can convert into a permit to operate. It's a very lengthy process and there's a lot of details involved. And while this is primarily driven by technology and engineering, legal issues can frequently come up in this process. A facility has to give information to the agency has to process it. Quite often there are public noticing requirements and CYLA requirements, California Environmental Quality Act requirements that go along with this before the permit is ultimately issued. These permits will often reiterate to that facility what other regional air regulations would apply to that facility. So because our agencies are regulating a wide range of stationary sources, our rule books can be very long. So it's important to check those rule books for any rules that might affect your clients. Because if you don't, you could end up finding, the client could find themselves in a situations where they are subject to enforcement action from the local agency, or maybe even the state agency or at the federal level as well. Criminal and civil penalties are available under California Health and Safety Code, section 42400. And so that's a big big part of what I do as an attorney for a regional agency is I help enforce my agency's regulations through civil actions in my county superior courts. And in doing so, I have to document the facts, I have to gather evidence, I have to tell the court what the violation was, and then also try to establish a fair penalty amount based on all relevant circumstances as the Health and Safety Code dictates. And the relevant circumstances can include things like extent of harm, the duration, the frequency of violation, and so on. So there are a lot of things that get considered as we try to first help the facility achieve compliance and then address through penalties any non-compliance that did in fact occur. There's also something called a variance. A variance is temporary relief from the requirements of air district rules. All air districts have a hearing board that will consider variances, and South Coast Hearing Board in particular is very active, but every air district has them, and so many attorneys will help their clients through the hearing board variance process. As with everything in this presentation, there's like so many things I could say about each of these things, but I'm going to move on and stay high level, and then we can talk in more detail about whatever interests you. As I noted, there's been a lot of progress in all the regions of California in improving our air quality for ozone and particulate matter. And so if anyone ever says the air quality is getting worse, in general, that's not true. Of course, there are going to be some ups and downs within these data sets, but happily, there's a strong downward trend in ozone concentrations and particulate matter concentrations. So that is good news. We want to celebrate that and acknowledge that the things we're doing are important and they're working and our residents are better off. There's still a long way to go. And so these particular charts represent the South Coast Air Basin, and they show the progress in that region with respect to a few of the EPA NAAQS or air quality standards. And that's another facet of this challenge. Is there are multiple standards our regions are trying to meet. For 8-hour ozone, there were standards adopted in 1997, 2008, and 2015. And so when you look at a region's progress, you're going to see dotted lines, these horizontal lines that represent the multiple targets that we need to be reaching. And there's different deadlines and requirements for each one. Similarly, for particulate matter, for PM 2.5, standards were set in 1997, 2006, and 2012. We need to meet planning requirements for each of these standards. We're seeing progress, but we still have some work to do in both South Coast and the San Joaquin Valley. And again, you're going to see in San Joaquin Valley, we are seeing a downward trend. We are seeing a little bit of variation in that trend, but overall, there has been progress made, and we do still have some work to do. So related issues. So far, what we've mostly talked about is the fact that EPA will set standards, and then regions and states have to attain the standards through regulations and permitting and enforcement. There are so many other things involved in air quality that we just don't have time to go into great detail on, but let's acknowledge what some of them are. Of course, climate change. This is such important work, and there's a lot to do here. Massachusetts versus EPA showed us that climate change can be dealt with under the Clean Air Act, but it really doesn't fit the same model as the criteria pollutants that are dealt with through EPA's NAAQS. And so there's still some work to do there from EPA in all levels in terms of addressing climate change in a more cohesive regulatory manner. But there's also environmental justice, which is a nationwide issue. But here in California, you may have heard of AB 617, under which the state will designate regions of our state as needing special attention and resources as environmental justice areas. And this is not limited to air quality, but is directly entwined with air quality, since these are regions that tend to have air quality challenges, and the regional air districts really take the lead in coordinating and communicating with those areas. There are also issues with transported air pollution and interstate pollution. That isn't quite as in the forefront of the work in California, since we're such a big state, but even within our state, we have to think about not only achieving goals for our region, but how is pollution moving throughout the state. Of course, wildfire impacts is on everyone's mind right now, because California is finding itself regularly impacted by wildfires in a very big way. On the one hand, because of EPA's exceptional event policy, This, with documentation, does not count toward an area's achieving attainment by the statutory deadlines. But of course, these wildfires are in fact impacting public health. So the various air districts do a lot to work with community groups to make sure people know when these impacts are happening and how they can protect themselves. It's the California mobile source waiver issue that I mentioned earlier. California can regulate mobile sources if EPA says they can, and then other states can use California's standards as well. And I think it's like 14 states use California standards, about 40% of the motor vehicle population in the United States. So now and then you'll see people in the media talk about this patchwork of regulations. It's not a patchwork. There's two standards, California and the federal. And there's been times in the past where EPA said, no, California, you don't get the waiver, and then courts will reverse that. More recently, California received a waiver, and then EPA took the waiver away, which led to a variety of litigation. And now EPA is looking to take away the takeaways so that California's waivers can be put back into place. EPA recently held a comment period on that. So that's a situation that's continuing to develop. Acid rain and stratospheric ozone protection are also part of the Federal Clean Air Act. And then you'll also see air quality issues come up through the California Environmental Quality Act, or CEQA. And we, as Marissa already mentioned, we do have a CEQA 101 webinar coming up later in September. So we hope that you'll join us for that as well. Air quality is part of that statutory framework as well. So we want to tell you a little bit about some work examples. You know, we've been a little bit broad brush so far, but what does this mean to a law student who might be aspiring to work on air quality issues in the future? And really, I wish, I'm biased, but I wish more attorneys did look to air quality as something that might be part of their practice area, both because there's a lot of important work to be doing at the various public agencies. There's a lot of important work to do to protect our communities in the nonprofit sector, and also just private attorneys representing various businesses and industries. We are all better off if we have a good understanding of what's at stake and what we need to do in a legally speaking, to address our air quality. So how does this come up in actual work? Well, one example is you might find yourself submitting comments to EPA, to CARB, or the local air districts regarding their proposed actions. I see this happen all the time. One of our agencies will post something that we're proposing to do. An attorney will represent a community group or a client and write a comment letter telling these agencies what they think of what they're doing, both in terms of the technical and scientific issues, of the policy issues that might be involved, as well as whether or not they think these agencies are meeting their legal obligations. So that's one kind of work product. So learning how to write a good comment letter, that certainly isn't limited to environmental law, but it's a very important skill in the practice of environmental law, not limited to air quality, of course. You might, along those lines, you might find yourself participating in related workshops and public hearings, maybe representing your client and verbally before these various agencies and boards. You can find yourself filing a citizen suit. One of the artifacts of the Clean Air Act and many other federal environmental regulations is the things that become adopted on the local and state level. Once they're submitted to EPA in the SIP, the State Implementation Plan, they become federally enforceable as well. So and with that, the Clean Air Act allows for citizen suits. Any citizen who can show standing can sue in federal court to make sure that the Clean Air Act and the federally enforceable plans and rules are being implemented properly. You can challenge an agency action, maybe through a writ of mandate in county superior court, petitioning either the Ninth Circuit or the DC Circuit for review of an action that EPA made. You can represent a client in determining the applicability and the implementation of permitting requirements. Say a facility isn't happy with what an agency is saying they need to do in their permit, they might hire a lawyer to interface with that agency to figure out what is actually required and whether there might be compromises that need to be made to make sure that the facility can operate their business while still satisfying the various legal requirements that are affect them regionally or at the state and federal level. You might find yourself representing a client in an enforcement action. As I mentioned, a lot of what I do is civil enforcement in the county superior courts. And quite often, of course, on the other side of those actions will be an attorney representing the facility or business that is being accused of violating a local regulation. So there's important work to be done there as well. As an attorney for a private entity, you might negotiate with the agency issuing the violation to your client to see if you could settle it and maybe reduce the penalty attendees or come up with some alternative compliance measures that will achieve better air quality benefits. You might represent your client in seeking a variance before one of those hearing boards before the regional agencies. So there are a lot of things that can be done to contribute to the implementation of regulations improving air quality at all levels of government and within all of these different agencies. So what are the opportunities in general? In-house counsel at a government agency such as EPA, CARB, or the local air districts, and even the Department of Justice is the agency that will represent EPA in court. So there's definitely opportunities in the public sector, but of course, opportunities also exist by serving as counsel for non-governmental organizations or NGOs, advocating for communities impacted by pollution. Or you might find yourself representing businesses and other entities subject to local and state regulations. So that's the big overview of all the important work that maybe you'll get to help us out with someday when you are practicing as an environmental lawyer. We did have several resources that we wanted to share with you. We'll have this PowerPoint presentation posted somewhere so you can access these resources more readily. But just to briefly keep this out here in case you want to take a screenshot or something for future reference, make sure if you're going to practice in air quality, get real familiar with EPA's National Ambient Air Quality Standards, obviously the California Air Resources Board, your local air districts. You can look to EPA's air topics. You can look at EPA's webpage dedicated to Clean Air Act permitting in California, the American Lung Association State of the Air Report, which I actually referenced earlier in the presentation. And then if you haven't found them yet, I'm also an adjunct professor, and I'm always recommending to my students the Congressional Research Service. They put together really good overviews of a variety of statutes, not limited to air quality, not even limited to the environment, but in particular their Clean Air Act, a summary of the act and its major requirements is a really great report. They're nonpartisan. They're just the right amount of thorough when you're getting your feet wet on these various issues. Marissa, do we want to go on and talk about other ways to get involved, or should we save that for later and maybe go to you and Byron for a little bit more information on your work?
Yeah, why don't we pop back 2 slides where you were showing some of the kind of categories of work examples. So yeah, Jesse, thank you so much for this whirlwind tour of environmental air quality law. I feel like I'm drinking from a fire hose, but it's fabulous just to like you said, kind of get your feet wet. And so hopefully people on the Zoom are not overwhelmed. And as she said, these will all be recorded and available. And we encourage you, if you're interested in this area, to poke around and learn more. And yeah, if you're interested in environmental law or you practice in another area, we are trying to cover topics that we think come up a lot. And so you will undoubtedly encounter air quality issues at some point in your life as a resident of California, and certainly as an environmental lawyer or working with a regulated entity, whether in a business capacity or development, land use. There are a lot of different areas that intersect. So I think I'm going to turn it over to Byron, and I would love, Byron, if you wouldn't mind introducing yourself and just telling us a little bit about your role at Earth Justice with the Community Partnerships Program. And I know that you personally have, worked on some interesting projects, just to give folks a little taster of what it is that you do and the types of work someone might encounter in their day-to-day.
Yeah, definitely. Thank you so much. Thank you to all of the attendees for being here. It's great to kind of nerd out on what, the details and really the power of the Clean Air Act to do incredible things. I think as Jesse's slides have shown, we've come a long way, but there's a long way to go. One of the attorneys I work with always describes it to me as basically, if you've been eating a triple bacon cheeseburger every day, right, for your whole life, that's not very healthy. And that's where we were several decades ago, eating triple bacon cheeseburgers, and now we're eating double bacon cheeseburgers every day. So it's a little bit better, but we're still not where we need to be. So there's still a lot of work to be done. And I hope that many of you are inspired and continue to work towards clean air for everybody. As Marissa mentioned, my name is Byron Chan. I'm an associate attorney at Earth Justice based in Los Angeles. Specifically, I'm part of the Community Partnerships Program. We go by CPP because it's a mouthful. So it's a relatively new program that's really focused on centering the lived experiences of fence line and frontline communities. It's more of an approach rather than necessarily a subject area. So while I do a lot of Clean Air Act work, I'm also involved, for example, on hazardous waste sites, lead, for example, and municipal waste too. And all of that work is really driven by the passion, dedication, and expertise of communities around facilities that are dealing with emissions, with groundwater issues, and with hazardous waste. The CPP program, just for a little bit more background, I'm based in Los Angeles and mostly working on local Los Angeles issues, but we also have attorneys in New York, for example, who are working on a municipal waste incinerator there, also the ports there as well. And we also have attorneys in DC who are working on a variety of local issues as well. So it's a weirdly kind of hyper local practice, but national in scope. And I just wanted to transition to talk about maybe one of the examples that Jesse mentioned was a citizen suit provision of the Clean Air Act that is really powerful and that I have some recent experience with. So I thought I could color that a little bit more. So last year, Earth Justice, me and my colleagues, we filed a citizen suit under the Clean Air Act. And we did that on behalf of our community partner in the Wilmington, Carson, and West Long Beach area. That community partner's name is East Yard Communities for Environmental Justice. And the citizen suit was against Phillips 66, which owns 2 interconnected refineries in Los Angeles. And Los Angeles has the highest concentration of oil refineries in California. And a majority of them, including Phillips 66's refineries, are within the communities of Wilmington, Carson, and West Long Beach, which already suffers from a variety of pollution burdens, including the ports of LA and Los Angeles, the goods movement, and also urban oil drill sites. So the citizen suit was based on violations of 2 rules at the South Coast Air Quality Management District. And those 2 rules dealt with leaking equipment. And I want to emphasize here that leaking equipment is really important. When I think of emissions from oil refineries or major facilities, my mind goes to black smoke coming from a flare or a smokestack, kind of like that Google Images picture if you just looked up emissions. But in reality, leaking equipment is the single largest source of VOC releases at refineries. And VOCs stand for volatile organic compounds. And those are basically just gases emitted from liquids. And VOCs are harmful for at least 2 reasons that I want to share with you. The first, as Jesse mentioned, is that VOCs contribute to ground level ozone, or smog as it's known. And Los Angeles is the most ozone polluted region in the country. As Jesse showed in her slides, in Los Angeles, where I'm living, communities last year suffered through 157 unhealthy ozone days, right? So that's nearly half of a year where the air outside is unhealthy. The second reason that VOCs are hazardous is that they're dangerous on their own, right? And they can cause long-term health consequences, including cancer, developmental defects, and nervous system damage. So that's just all to say that these leaks are really harmful and dangerous. And to deal with these emissions from leaks, the South Coast Air District passed 2 rules. So I hope this kind of follows what Jesse was describing as far as the rulemaking process. So you have these leaks, and the Air District passed 2 rules. The first was Rule 1173, and the second was Rule 1176. And both of those rules require oil refineries to inspect their equipment and make sure that their equipment isn't leaking. And as part of those inspections, oil refineries have to submit their inspection records to the Air District for review. So what we did is we used Public Records Act requests. So I'm sure there's a whole nother webinar or CLE on the Public Records Act request, but basically any individual can request public records from an agency. So we submitted those Public Records Act requests, and specifically we requested those inspection records that Phillips 66 submitted to the Air District based off of their inspection records of those leaks. And what we discovered is that Phillips 66 wasn't conducting the necessary inspections and repairs required by the Air District's rules. So we ultimately worked with our partner, East Yard Communities for Environmental Justice, to file a citizen suit under the Clean Air Act based on the violations of those two Air District rules. And the first step in filing a citizen suit is filing a notice of intent to sue. And the notice is basically, it's a wake-up call to EPA, to the Air District, and also, in this case, Phillips 66, to let them know that there are violations of the Clean Air Act going on. And it's meant to give those agencies and the refinery, in this case, an opportunity to address the violations within a 60-day period. So with the filing of our notice of intent to sue, we began to engage in discussions with Phillips 66 to address the violations at its refineries. And we ultimately crafted a settlement agreement that improved the refinery's leak detection and repair program, and also included supplemental environmental projects. And those projects the projects aim to provide health benefits to the fence line communities that are most impacted by those violations of the Air District's leak detection and repair rules. So that's the matter, but and that was the end of that matter, but our work really never ends. And that's because the air in Los Angeles remains so unhealthy. So we continue to monitor refineries in Los Angeles with our partners to ensure that refineries are held accountable, right, through a variety of tools. And one of those tools is the citizen supervision of the Clean Air Act.
Thank you so much, Byron. Yeah, I think that certainly air quality is one of those issues that kind of cuts across a lot of different areas. So there's public health implications, and there's a lot of environmental justice concerns, which are finally getting a lot more attention. So in an earlier slide, Jesse mentioned A617, but there's a lot of legislation and focus, and a lot of good attention on these issues because we do have problems in California. I will just share a few examples for the last few bullets, just to give you a little taster in terms of representing clients and determining the applicability of permitting requirements. One project I worked on was with the Bay Area Air Quality Management District, and we have a client who owns a defunct landfill. It's a landfill that's closed, so it's no longer accepting hazardous waste or processing anything. And that's kind of an issue where there's a lot of regulation around landfills, particularly with methane emissions. And there's questions about whether or not they're still subject to the federal Title V permitting regime, which is a pretty significant regime with a lot of requirements, or if they can get kind of lower tier permits that don't have quite as many obligations since it's no longer operating actively. Moving down the coast, talking about representing clients in enforcement actions. As Jesse said, sometimes she's on one side, the agency has issued notices of violation, and then there's kind of three tracks you can try to settle through, like a mutual settlement program. You can refer out to the DA, or the attorney at the Air District can prosecute their case themselves in civilly or criminally, and there are often monetary penalties associated. Or you can also kind of go an administrative route. So the regional boards, they each have a hearing board, and they can issue abatement orders, which are basically injunctive relief, or they can also impose administrative penalties, which have their own factors and formulas. So anyway, I have a client that is in the Santa Barbara area, and it's kind of fun. It's a cannabis company, and they've been having some issues with air violations. And so, yeah, we're currently negotiating with the air district and trying to figure out, what the remedy will be and how much the penalty should be. And then the last example with the variance, I've worked with a client who, it's an energy company, and they built brand new power plants that were actually replacing these old rundown power plants. And they had the full permits to construct and operate. But what neither the client nor the agency realize is that when you start up a brand new power plant, there's a lot of issues that you have to go through to make sure it's calibrated and tuned up and working properly. And so we had to go do an emergency variance hearing in front of the AQMD, the South Coast AQMD hearing board. And a variance is basically, it's kind of like a special permission or a special exception. And so they adjust portions of your permit, and then you're allowed to do what needs to be done just for a temporary period of time. In our case, it was for the 1 or 2 weeks while they were getting this new plant online. But anyway, those are just some examples of the types of work, environmental lawyers can do. I know Jessie, I mentioned at the beginning, she's been involved with some of this federalism stuff in terms of, upholding the Clean Air Act requirements and litigating in the Ninth Circuit and DC Circuit. So I think there's a lot of interesting opportunities available. The next slide, I think Jessie already ran through, but we basically represent those sort of three large categories. You can be someone like Jessie, where you are in-house at an agency. So she's at the San Joaquin Valley Air District, which is a big district. And then Byron is at Earth Justice and working in NGO. I personally, I only worked in private practice, but I interned at Surfrider one of my summers. So there's a lot of overlap and interchange, I would say, in environmental law between different areas. And then, yes, if you're a firm lawyer, you end up representing regulated entities. I think on the next two slides, the next one is just the resources. So again, if you want to learn more, check out these links. I just wanted to highlight a few ways to get involved with these organizations. As I mentioned, they're nonprofit volunteer organizations, but just as in law school or college, you have alumni associations and affinity groups. They're just good ways to get involved with the profession. So once you graduate and are admitted to the bar, definitely check out the California Lawyers Association, the Young Lawyers Association for the first 8 years, or if you're interested in a specific practice area, you can join a section. And we all host a bunch of programming. There's both virtual and in-person events. There's a lot of ways to earn continuing legal education. So everyone needs to do, X amount of credits every few years in order to keep their licensure. And so attending these events and watching the videos is a good way to earn some of those. Most of the sections have publications, so people can submit articles. And then just wanted to mention for folks who are not lawyers and are, not graduated yet, there are a lot of resources that you can still take advantage of. We have social media and YouTube accounts. The Young Lawyers Association has these fun 10-minute mentor videos. I think this recording will be on the Environmental Law Section's YouTube channel. ELS sponsors annually a law student negotiation competition, and we're hoping to launch a writing competition. Anyone in the community is welcome to join our book club. Jesse spearheads that, and there's.
Can I talk about it real quick?
Yeah,
it's one of my favorite things in the world. I love our book club. I hope you'll consider joining us for one of our books. We've been meeting since the pandemic started, every month, every other month. But in September, we're going to be talking about a short circuiting policy, which is a book about energy policy. In October, we're going to be reading and discussing Black Faces, White Spaces, about equity and inclusion in natural environments and the environmental movement. Really great book. And then in December, we're going to read a novel, Richard Powers' The Overstory. These are free conversations, and even if you don't finish the book, you can join us. We have a lot of fun talking to like-minded people from all over the state. So something to, I mean, a lot of you are law students and you don't have time to read, but if you are not a law student and you do have time to read, I hope you'll consider joining us.
And I'll mention that Jesse's had a pretty good track record of convincing the authors to actually join for the conversation.
It's drying up a little bit, but I know we'll have the author Carolyn Finney in October, so that should be a really great conversation.
Yeah, so as part of our big Yosemite conference in October, the author of the Black Faces, White Spaces will actually be present. And, that's another great, I think worthy conversation about racial diversity and environmental justice and sort of the makeup of people interested and involved in environmental law. I think that's about it. Oh, the very last thing I wanted to highlight is we do also every year, on the next slide, sponsor summer internships. They are diversity and inclusion fellowships, and basically the section helps place students at great public interest orgs like Earth Justice, NRDC, government agencies, and it gives people stipends and pairs them up with a practicing environmental lawyer for some mentorship and education throughout the summer. So I believe the applications are going to open soon, or they're live, and so that will be for summer of 2022.
Yeah, they usually go live in October, so I don't think it's up yet, but definitely keep an eye on that and watch our social media for updates.
Yeah. So as I said, there are a lot of great resources out there. All of these organizations. These are the contact information. Feel free to reach out, check out the websites. And I think we have a few minutes, so I'll lob a few questions your way.
And I'm going to cheat. Like, I've already been looking at the questions. So can I just zip through some of them? Like, I'm really excited. You guys have really great questions. One person asked, have the large forest fires in the last several years shifted the summer focus on ozone to PM as well? I mean, to some extent, yes. I mean, we're always monitoring for particular matter and alerting to the public to when they need to protect their health for particular matter reasons. From a regulatory standpoint, it's very challenging. I mean, how do you cut back on forest fire use? Well, I mean, that's largely a federal issue and a state issue. And so it's super complicated, but it is important to track. And that's a dialogue that's going to keep unfolding. On related note, I think the drought and the lack of water is also going to have impacts to air quality as well. It's things get drier and more particles become suspended. The PM 2.5 that just adds to how complicated it is. And it also illustrates sort of the fact that we tend to tackle environmental problems separately. There's water law, there's air quality law, but there's so much overlap. Nature doesn't care about how we've drawn the lines in terms of the statute. So it's complicated, it's developing. It's a great question that I can't answer right now, but I think you're thinking about the right things. Someone asked about ISR as a means to regulate tailpipe emissions. I will carefully suggest that we don't talk about ISR in terms of regulating tailpipe emissions, but talk about ISR in terms of trying to decrease emissions that come from mobile sources by looking at development patterns and not regulating tailpipe emissions themselves, because indeed that is the nature of that particular case. That is developing. I've got my eye on it for sure, but what I wanted to mention to you, my own agency's indirect source review rule was approved in 2005, and we prevailed through two different legal challenges, one on the state level and one on the federal level. If you want to email me for these citations later, you can, but I'll read them to you real quick. If you look at 178 Cal App 4th 120, again, that's 178 Cal App 4th 120. That was the California Building Industry Association versus the San Joaquin Valley Air District. And then at the federal level, the other case, and that first case was 2009. The second one is 627 F3D 730. Again, that's 627 F3D 730. That was a 2010 case, the National Association of Home Builders versus San Joaquin Valley Air District. So we were challenged both state and federal court, and we prevailed. So I'm hopeful that South Coast is successful in defending their regulations as well. Someone asked about knowing the exceptions for when an ATC or PTO are not needed before installing equipment. It is very complicated, and it varies by region, and it varies based on facility type. So if you ever find yourself in that situation where you're either representing a business or a community group that's interested in whether something needs a permit, interface with your local air district, reach out to them, talk to the permitting department, figure out whether or not a permit is required. For my own agency, we have a regulation called Rule 2020 exemptions, and that has like the big categories of exemptions, but then individual rules might have exceptions to certain kinds of requirements. So sometimes when you're in a hurry and maybe you're newer to the practice, you see a title and you look at the requirements and you don't look at the applicability or exceptions and exemptions. So pay really close attention to that if you're advising a community group or a facility about these things. Someone asked about how they can get information on SIPs, the state implementation plans. You can get a lot of information on EPA's website, but I do encourage you to look specifically at the individual regions. You know, go on their web pages, look at their air quality plans, and if you can't find it, do a public records request. Byron mentioned that earlier, and it's something that I tell my students as well. And in the practice of anything administrative, you got to get familiar with Records Act requests to make sure you're asking for the documentation that you need. Okay, I'm trying to look through some of these others and see what else we can tackle. Someone asked about San Joaquin Valley and oil production and whether there's policymakers are discussing relocating communities. No, there's really no talk, on an agency level talking about relocating communities, but I will say that AB 617 is doing really good work here and helping communities dialogue and communicate with their agencies to get more information and try to protect those specific areas. And that part of what's so complicated, as if this wasn't complicated enough, these air districts, we don't have planning authority. We don't have land use authority. We're not saying what goes where, but we are still regulating these entities. And there's just a lot of layers to this. And that is not a conversation that's happening yet, but who knows, maybe in the future. And Byron and Marissa, I'm sorry to just like take this over. Do you guys want to address any of these other questions that maybe I missed?
I was going to say, Byron, did you have any comments on the fire question? So someone asked, have large forest fires in the last several years shifted the summer focus on ozone to PM? Is Earth Justice thinking at all about, how these forest fires are impacting communities and disadvantaged communities?
I personally have not worked on that specific issue. We have attorneys in San Francisco that are working on that issue. And I think, yeah, Jesse did a great job of answering that question. So yeah, nothing to add from me.
Yeah, and I'm sorry, because like, I know there's only a few minutes left. I'm just trying to kind of like broadly touch on a lot of it. Someone asked about, from a nonpartisan standpoint, if we have a change in governor, how might that affect how we regulate air quality? For better or worse, the regulations don't change very quickly. And so it's not very easy for a state or EPA or even a region to just revoke stuff that's already been done. It's not impossible, but because the state and local rules have been submitted to EPA for inclusion in the SIP, that makes it even harder to backtrack on those things. Now, in terms of funding grants and when we have monetary incentives to accelerate fleet turnover, for example, someone could change how much funding is going to individual programs, which is another area we didn't even talk about today. So yeah, food for thought on that one. Scrolling through.
I see one at the very end. It's interesting. Someone said a client believes it needs more workable emission limits. Should they look for an environmental attorney or an engineer? If
Yes.
so, where should they look? I would say you probably need both, and that you need engineers and consultants to help you figure out what are the technical limits, what are the options, what's feasible. Then, as Jesse said, lawyers can help in different ways. They can help interface with the agency. They can help you if you want to submit comments, if there's a rulemaking. And also if you get into any kind of enforcement or issues with violations, they can try to help you work that out as well.
I think we're out of time. That went fast.
Yes. Well, thank you everyone for joining us. I know there are a few more questions, so we'll save those, and feel free to reach out to people individually. And if we can, we'll try to follow up on anything outstanding. As I mentioned, we have another session on water law in a couple of weeks, September 2nd. I think the week of September 13th, we will have CYLA 101. And then we'll lead into the Yosemite Conference in October. But these will all be available online, and we thank you for joining us.
Thank you. Bye.